Chair recognizes the gentleman from Lincoln for further explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. House Bill 1 is the Adoption and Foster Care Reform Package. It is a bipartisan piece of legislation that has come from hours upon hours of hard work and research. This process started almost a year ago when the gentleman from Russell 83 established a House working group on adoption, and I am truly thankful to him for doing that and his willingness to do that. The members of that group were the gentleman from Crittenden 4, the gentleman from Fayette 88, the gentleman from Jefferson 37, the gentleman from Franklin 57, the lady from Clark 73, the lady from Muhlenberg 15, the gentleman from Bullitt 26, the lady from Jefferson 44, and myself, all of whom have co-sponsored this bill. Throughout the course of that time, the group met 7 times in public meetings and countless meetings with various groups and individuals. We met with foster parents, foster children, adoptive parents, the Cabinet for Health and Family Services, the Administrative Office of the Courts, judges, attorneys, and adoption and foster care agencies. The results of those meetings led to recommendations from the work group to the Speaker in December. From those recommendations, we have crafted House Bill 1 that makes sweeping changes to the child welfare system here in Kentucky. As I go through this explanation of the bill, it may get quite lengthy, so I apologize to the members in advance. But this is a very pressing issue in our state as it is across the nation, and I want to ensure that each and every one of you fully understand what we are proposing here today. First, we know that reforming this system of this size cannot be done in one bill. It cannot even be done in one session. It will be ongoing. This bill is simply a start. The issue we are facing with increased number of children coming into state custody is concerning. The future of Kentucky is important, and the children of this state are our future. We need a greater focus on those in this system. That is why we established a new statutory committee here in the General Assembly that is entitled the Child Welfare Oversight and Advisory Committee. This committee will be responsible for ensuring all parties involved in foster care and adoption are doing what is absolutely best for the child in each case. Next, we established a more independent office of the Ombudsman within the Cabinet of Health and Family Services. The Ombudsman will still be under the Secretary, appointed by the Secretary, but will not report directly to that Secretary. That is similar to how the Inspector General operates independently within each Cabinet. If there is a complaint that involves the staff of the Cabinet, the Ombudsman will report directly to the Inspector General in those cases in order to avoid any conflicts of interest. The Inspector General will then determine if there needs to be an investigation from that point forward. We're expanding the definition of a blood relative to mirror the interstate compact of the placement of children. Most courts already use this expanded definition to allow for more options for children to stay with family when removed from a home. One additional thing that we are doing here is adding fictive kin to this definition, allowing them to be placed with someone that may not be family but has a relationship with that child. This bill also places an emphasis on ensuring that a placement is in the child's best interest and focuses on keeping the child as close to home as possible if it is safe to do so, to ensure as little disruption as possible in that child's life. One small change that is made in the bill is that statute that pertains to foster parents being able to make haircut decisions for a child. While we firmly believe that foster parents need to be able to make those decisions that are about the best care for a child that they are bringing into their home, we do need to add one clause. The statute currently states that foster parents can make decisions about haircuts. However, there have been some instances where hair is directly related to religious beliefs. One example that was given to us was where a Native American child being in custody had their hair cut off. This was contrary to any of their beliefs, and so taking this into account, we have added a clause that says foster parents can make those haircut decisions unless the Cabinet determines that in certain cases it needs to be restricted due to religious, racial, ethnic, or national origin. Now for major changes in this bill. These are the things that are really going to impact this system. First, we're requiring the Cabinet to implement timelines to ensure children committed to the Cabinet are timely reunified with their biological family or their goal is changed and placed in a new permanent home. The Cabinet will continue to do their 6-month reviews and submit to the court, but we're adding additional language that will require an additional case review every 3 months. This is to create a better focus on each child and ensure we are continuously doing what is in the best interest of each child. Another timeline is that once a child has been in care 15 cumulative months out of any 48-month period, the Cabinet must either reunify the child if it is safe to do so or petition for the termination of parental rights. Now, this does not mean that termination will occur, but if and when the court decides that is the path to take, everything will be ready. Also, when the Cabinet determines it is not in the best interest of a child to be reunified, the biological parent may appeal that determination within 30 days of the Cabinet's decision. The Cabinet will make a review of the appeal and make its final decision within 3 months of that appeal being filed. This is a large factor in delays by allowing these appeals to be drug out for months and months. Also, currently statute says that when a parent voluntarily terminates rights through a consent order, that order becomes final 20 days after approval from the Secretary of the Cabinet of Health and Family Services. This is an unnecessary step. Again, we are talking about the voluntary termination of rights. What happens in some of these cases due to an overwhelming workload in the Cabinet is that that consent order may sit on a desk for several months prior to approval. Then the 20 days starts at that point once it is signed. What we are changing is this is to mirror many other states in saying that the order will become final 30 days after signing of the consent order by the birth parent. Also in this bill, we are implementing timelines for the court system. It establishes a maximum 30-day timeline on which an appeal for an involuntary termination of parental rights may be filed. The court would then have 6 months to make a final judgment on that appeal. We are establishing changes to help resolve conflicts regarding service of process in a timely manner for parents involved in a pending case. The bill establishes that a case may be filed in a county where the child resides. An example of why this is needed is there may be a child that is staying with a boyfriend or a girlfriend of a parent, say in Jefferson County, and there's an instance where that child ends up having to be removed from that home. At that time, the case is then filed in Jefferson County, even though that parent may live in Oldham County. Then that case ends up being transferred to the county where the child resides. That transfer delays the process, and so AOC has proposed that we allow that the courts go ahead and file that case in the county where the child resides to speed that process up. Also, in the case of a petition for voluntary termination of parental rights, there is an added timeline that the final judgment by the court in those situations be made within 6 months of filing that petition. The next thing is sometimes there are criminal proceedings occurring at the same time a DNA or custody case is occurring. What happens in these instances is that the attorneys in the criminal case will not allow their client to participate in the DNA case until the criminal proceedings are finished, due to fear that something in the DNA case may be used against them in the criminal case. AOC has come up with a recommendation. I'm very proud of them for this recommendation, to add that these two cases can proceed simultaneously and that evidence in the DNA case will not be admissible in court unless it is used for the purposes of impeachment, say a witness has lied or something to that effect. We've probably all heard of the issues in the past of limited access to confidential information in cases between the courts and the Cabinet. The bill establishes an agreement between the courts and the Cabinet to hold on how to handle confidential information that is beneficial in DNA and criminal cases while keeping focus on what is in the best interest of the child and their safety. The bill requires the Cabinet to do 2 studies. The first is a study on how to implement performance-based contracts and the best model for doing so. The study will be presented to the Child Welfare and Oversight Advisory Committee by December the 1st of 2018. The Cabinet will then implement performance-based contracts by July 1st, 2019. Because we believe that if we are going to make private companies operate under a certain standard, we should require the same thing of government. Therefore, there's a clause added to say that whatever standards and scorecards are used for private agencies, the Cabinet must comply with those as well. The second study requires the Cabinet to research fully implementing privatization in the foster care system. Again, this is just a study, but however, our system is currently 56% privatized, so it is not a difficult task or a far reach to fully privatize. Like anything, there are varying degrees of success in privatization, and many states have been highly successful. We can learn from those states that have been highly successful as we do this study. The goal for this would be to lower those caseloads that our workers are facing over in DCBS and get them back to focusing on what they do best, and that's the investigations. It has been expressed to me that there is a fear from folks in the Cabinet of losing jobs if this privatization were to happen in the future. That is definitely not the intent. And the Cabinet is in such need of workers right now that if it were to be privatized, all those employees would be needed in other areas. The next thing we do, which is a big one, is neonatal abstinence syndrome has become a major concern in our state. With the drug epidemic continuing to flourish, more and more babies are being born drug addicted. 15 years ago, hospitals saw maybe one drug-addicted baby every 2 to 3 days. Today in our country, it's more than one baby per hour that is born drug-addicted. And Kentucky is among the top states for drug-addicted children per capita. As I've been doing the research, I've watched videos of horrible suffering of children going through this drug addiction. Violent shaking, excruciating pain, and no way to be comforted except for being doped up on morphine. This is unacceptable. So the bill creates a section in the termination of parental rights statute that says if a child is born drug addicted, a parent would have 60 days to enroll in drug treatment, or the cabinet is petitioned for termination of parental rights. This is twofold. It takes a step to force a parent into drug intervention, and it works towards the protection of those children. The next thing that this bill does is establishes a putative father registry here in Kentucky. Currently, 27 states have some form of putative father registry. Also, we have researched these registries. It seems that most experts agree Indiana has the gold standard. We have tailored this registry so that it is similar to Indiana's. I'll explain to you first what a putative father is for that definition. A putative father is a potential father. It is a man that was not married to the child's mother before the child was born, and his relationship has not been established by legal proceedings. Currently, if a woman makes a decision to place a child for adoption, the cabinet is required to ask who the father is. However, the woman does not have to give any names. Should a birth mother choose not to disclose the birth father's name, his rights are removed from him. This registry expands the rights of men who think there is a possibility they are a father of a child. If he feels he potentially may be the father of a child, he has the opportunity to register his name in a confidential registry saying he would like to have rights to that child. He will then have the right to be notified of any court proceedings regarding the child, including petitions for adoption or termination of parental rights. He then has the decision of objecting to the adoption or allowing it to proceed. It makes the government inform the father of possible parental rights of the father, making it easier to find him, notify him, and invoke his parental right if he so chooses. What we are focusing on in these situations are where the man has not been involved in the woman's pregnancy, helped her or supported her in any way, or simply does not want to be found. That situation does nothing but allow a child to linger longer in the system during the most crucial time of development in their life. If the man is married to the woman or he has been in a standing relationship with her, there is no need to register. That relationship is verification that the man would already potentially have rights to that child. If he feels that he potentially is the father of a child, he may register at any point up until the time of the child's birth. That gives him an additional 9 months to exercise his rights. If there is some rare instance that the man did not know he could potentially be a father and has no knowledge of that at the time of the child's birth, he would have 30 days after the birth to register. We have added an additional portion to this registry that Indiana did not include in theirs, and that is through the cabinet's interview and background process. If they determine the name of a potential father, they then must notify that father of his right to have his name included in the registry. This registry is in addition to the other means already included in statute to prove a man could potentially have rights to a child. We're not taking any of those other means away, such as he has assisted a mother through pregnancy or helped with paying for medical bills or care of the woman and child. As we went through this process, we realized that foster parents don't have much of a voice in the system. They feel that way. And after our research, we've come to the conclusion that we believe that they are correct in that. And so, after listening to testimony from several foster parents and feeling justified in their feelings, this bill adds language to help rectify this situation. So this next section is a big section for our foster parents across the state. You may have heard those stories of a child being moved to another placement without warning, and that those children and their things suddenly are packed into a garbage bag and they're taken to their next placement. We have added language in here that says the cabinet must give a child and foster parents a minimum of 10 days' notice prior to a move unless there is a case of imminent danger. This is to allow the child and the caretakers time to prepare for that move. Kentucky has a foster parent bill of rights. However, through our research of that bill of rights, it was discovered that through technical language, it did not pertain to all foster parents. And that is because the cabinet has partially privatized over the years. That bill of rights is worded so that it technically does not pertain to foster parents and private agencies. This is not intentional. It has just not been updated in some time. So we've expanded the language to ensure that we include those foster parents. There's also new language which is a big one for foster parents, that give them the explicit right to receive notice, have the right to attend and be heard in any court or cabinet proceeding, whether that be by written or oral testimony. We also want to make it very clear that there can be no forms of retaliation against a foster parent for speaking out or testifying in any proceedings. Through the work that has been done with the Administrative Office of the Courts, we've expanded the Citizens Foster Care Review Boards. We've asked AOC if they had any thoughts on how we could allow foster parents more of a voice in these boards. AOC liked this idea. They came back with some suggestions, and they did want to expand those boards. And what they came back with is that the foster care review boards would hold a portion of their board meetings that would allow an open time for anyone who is a party of a case to come in and speak in that district. This is to allow those foster parents the ability to give feedback and voice the concerns in order to continue improvements in the system. At this time, Mr. Speaker, I would like to yield to the gentleman from Spencer 53 for a friendly floor amendment.
Chair recognizes the gentleman from Spencer for friendly floor amendment.
Thank you, Mr. Speaker.
Mr. Speaker, I apologize, gentleman from Spencer. I need to, before we do that, I need to call the House Committee substitute. So if you would, I would ask the clerk to report that.
Mr. Clerk, please report.
House Committee Substitute 1 to House Bill 1.
Gentleman from Lincoln.
Move adoption.
Motion is for the adoption of House Committee Substitute 1. Is there any discussion? All in favor signify by saying aye.
Aye.
All opposed, nay. House Committee Substitute 1 is adopted. Gentleman from Lincoln.
Now I would yield to the gentleman from Spencer.
Chair recognizes the gentleman from Spencer.
Thank you, Mr. Speaker. Would you have the clerk report House Floor Amendment 2?
Mr. Clerk, please report.
House Floor Amendment 2 to House Bill 1.
Gentleman from Spencer.
Thank you, Mr. Speaker. Thank you, gentlemen from Lincoln, for your willingness to work with me on this provision. Several months ago, I had a constituent come and meet with me. This constituent's in a similar situation to, I'm sure, many of your constituents. Their grandparents, and through unfortunate circumstances, they're caring for the grandchildren. And grandparents have a tough time in our system. A lot of times, this is a responsibility they did not foresee coming. A lot of times, this is a financial burden. Many of them are retired. And one of the situations they explained to me is when there is a court hearing dealing with their grandchild in these type of situations, they felt like they had no voice. They had no opportunity. What House Floor Amendment 2 will do is it clarifies that a person claiming to be a de facto custodian has the right to legal representation in custody actions. It also allows the circuit court to determine if this de facto custodian is in an indigent situation, and if they do find that, they can report that to the custodian, and if they so choose, they can request to have legal representation in any court hearing, and it does approve the Department of Finance to expend up to $500 to pay for that representation. For no questions, I move adoption of House Floor Amendment 2.
Motion is for the adoption of House Floor Amendment 2. Is there any discussion? Those in favor signify by saying aye.
Aye.
Those opposed, nay. House Floor Amendment 2 is adopted. Gentleman from Lincoln.
It's time I would ask the clerk to call House Floor Amendment 3.
Mr. Clerk, please report.
House Floor Amendment 3 to House Bill 1.
Gentleman from Lincoln.
House Floor Amendment 3 makes several technical changes and language corrections by simply separating some sentences. Nothing major in those changes. However, it does make one major change. There have been concerns about unintended consequences of making a criminal offense if a child is born drug addicted. In the original bill, in the committee substitute, actually, we included it that it was not only for the termination of parental rights, but it was also a criminal offense. So there have been some concerns that the mothers may not seek prenatal treatment or not be willing to deliver in a hospital and put the health of the child at risk if that were the case. So what we're doing is we're leaving this in the termination of parental rights section. So if a child is born with neonatal abstinence syndrome and the mother does not seek drug treatment within 60 days, the cabinet will still petition for TPR. It would just not be considered a criminal offense. Make no mistake, though, when you see these children born drug addicted and what they're suffering through and the pain that they experience, unable to be consoled, spending weeks or even months of their first few days of their life in an enclosed crib being fed morphine, it's one of the worst things that you can do to a child. It's not acceptable, and it should be a crime. And people should be held accountable for their actions, and that's what we're going to do with the termination of parental rights section. However, right now we feel that the potential for unintended consequences are too great, and we know this is an issue that we can revisit later if necessary. So House Floor Amendment 3 simply removes that from the criminal statute, but it remains in the termination of parental rights. So with that, Mr. Speaker, I would move for adoption of House Floor Amendment 3.
Motion is for the adoption of House Floor Amendment 3. Is there any discussion? Chair recognizes, lady from Jefferson, do you wish recognition on the amendment? You're recognized for discussion on the amendment.
Thank you, Mr. Speaker. Will the sponsor yield to a question?
He will yield.
Just out of clarification, what does it mean to maintain substantial compliance with both the substance abuse treatment or recovery program?
Gentleman from Lincoln.
It simply means that when she is enrolled in that first she has to enroll in that program. Once she is administered to that program, she must maintain that program until the court has determined that she is ready to proceed.
All right. Thank
Lady
you,
from
Mr.
Jefferson.
Speaker.
Thank you, lady. Motion is for the adoption of House Floor Amendment 3. Is there any discussion? Seeing none, all those in favor vote aye. All opposed, nay. House Floor Amendment 3 is adopted. Gentleman from Lincoln.
Thank you, Mr. Speaker. In closing, it takes a special love for a family to adopt a child. I can tell you as a father of a biological child and an adopted child that there is no difference in that love, because love has no boundaries. It takes a lot of time, a lot of effort, and a lot of money to adopt a child. It's an emotional roller coaster to go through this process. You complain about it, you get upset with the system, but the moment you hold that child in your arms, you know you'd do it 1,000 times over if you had to, because of that love that you have in your heart. The same is true for birth mothers. Many times society labels birth mothers who choose to place their child for adoption as cruel people or who don't care about that child, but that's not the case. It also takes a special kind of love for a woman to say, I know that I can't take care of you, but I love you so much that I'm willing to give you life and allow you the opportunities that a loving family can provide for you. And I'm very grateful to the woman that gave birth to my child, because I know that she gave her that life and she has given her other opportunities. Again, it takes a special love that only foster parents can offer to bring a child they many times don't know into their homes and care for them as their own. They want to protect those children at all costs. We owe it to all these children, the parents and the families across the state, to start reforming a system in desperate need. Despite what some may say, we do this job as legislators because we want to make a difference in people's lives. All of us do, Democrat and Republican. We have all come together to create a package that will make a difference, both parties, the House, the Senate, AOC, the Cabinet. And we definitely couldn't be here without the First Lady and Governor making this a priority. But we have all come together because we put everything else aside and just made decisions based on what we feel is best for the children. Everyone knows what it takes to do this. The Cabinet said it will stretch us further, but if it's the best thing for the children, we're ready to do that. The court said it will cause us to prioritize things differently and rearrange dockets to meet timelines, but we're willing because it's what's best for the children. The executive branch and the legislature know that we have to give additional resources to the Cabinet. We will do all we can because we know that it's the best thing for the children. I am proud of everyone that is involved in this, Democrats and Republicans alike. This is an opportunity to do something truly remarkable for the children and the families of this state and to start changing lives for some of the most vulnerable. And so I ask for your support on House Bill 1. So with that, Mr. Speaker, if there be no questions, I would move adoption of House Bill 1 as amended by House Committee Substitute 1, House Floor Amendment 2, and House Floor Amendment 3.
Question before the body is for passage of House Bill 1 as amended by House Committee Substitute 1 and House Floor Amendments 2 and 3. Is there any discussion? Chair recognizes the lady from Jefferson 41 for discussion of the matter.
Thank you, Mr. Speaker. Will the sponsor yield to a question?
He will yield to a question.
Thank you. Section 28, number 3 on page 59 talks about the putative father registry. Can you talk about how that will be enforced if someone doesn't register? I'm not really clear how this registry works.
Give me that page number again, lady, if you don't care.
59, section 28, number 3.
Mr. Speaker, may I ask again what line item that was again? I apologize.
Well, I mean, it's the whole section, but really, number 3 of section 28, which begins that section on page 59.
I got the bill right here.
It's the amended version. That might be why it's difficult to find.
Section 3, you're talking about where the cabinet establishes putative father registry and promulgate administrative regulations?
Yes.
Again, that is we assume that the cabinet will go by something similar to what Indiana has done and has set the administrative regulations. We lay out most of what the putative father registry will do in this, except for like the postings and things like that, which right now most states post those in your driver's license, places you will see driver's license that you must register on putative father registry, hospitals, in those type areas. So that's what we assume that they will set in those administrative regulations, and also how they will set up the website and things like that where you would go and register and how to keep that confidential. So those are the things that they will be working on.
Thank you. May I ask another question, Mr. Speaker?
He will yield another question.
Thank you. Section 29, number 5, page 62. So number 5 talks about the circumstances under which one or more putative fathers are registered. Can you, I don't really understand that. Can you talk about what that means? What are some examples where you would have one or more putative fathers registered?
Gentleman from Lincoln.
Lady, there are instances where there have been instances where a woman may not know exactly who the father is, and there may be 2 or 3 potential fathers, and so that is what that is talking about in that case, where they have registered, and they would all at that time be notified of this if they could potentially be the father.
Thank you.
Lady
Thank
from
you, Mr.
Jefferson.
Speaker.
Thank you, lady. Chair recognizes the gentleman from Critton for discussion of the matter.
Thank you, Mr. Speaker. In the relatively short time that I've been in this body, I believe that participating in the adoption and foster care task force was quite possibly the most important thing I've ever done. I'd like to thank the gentleman from Russell for appointing me to the task force, and I would like to commend the gentleman from Lincoln and the lady from Jefferson 43 for the fine job they did in running this committee. I have 2 comments on the measure, however. Number 1, with regard to House Floor Amendment 3. Children being born addicted is not a new problem. Over 30 years ago, my wife and I fostered, and we had children like that. So I voted for adoption of House Floor Amendment 3 because the parents can still be held liable, but I do feel they should be held criminally liable. The second point I wish to make is that it's about time we had a bill that put the welfare of the child first. When you look at current Kentucky law, current federal law, the most important thing that they say to do is to reunite the child with his or her birth family. And while that's a noble goal, it does not address the fact that quite often that is not, in fact, the most important thing being what is right for the child. So, Mr. Speaker, members of this honorable body, I strongly encourage you to vote yes on House Bill 1. Thank you, Mr. Speaker.
Thank you, gentlemen. Question before the body is passage of House Bill 1 as amended by House Committee Substitute 1 and House Floor Amendments 2 and 3. Is there any further discussion? Seeing none, Mr. Clerk, sound the chimes. Those in favor vote aye. Those opposed, nay. And the roll call machine is open for your vote. All members voted. Does any member wish to change or explain their vote? Chair recognizes the gentleman from Garrett for explanation of vote not to exceed 3 minutes.
Mr. Speaker, riding up here today, I told the gentleman from Lincoln that I would try not to get too emotional with this, but I want to commend him, and the reason that I'm voting yes is because I know the heart that he has and the work that he's put into this. I'm voting yes for 3 reasons. 1, because I'm so proud of him. 2, because my oldest son, Jackson, who's 7 years old, is an adoptive son of mine. And 3rd, because of the 8,000 kids that are in foster care and so many more who need to be in a loving home is the reason that I'm voting yes today, Mr. Speaker. And I just want to reiterate how proud I am of the gentleman from Lincoln. Thank you.
Thank you, gentleman. Chair recognizes the lady from Boone 66 for explanation of a vote not to exceed 3 minutes.
Thank you, Mr. Chairman. You know, as I listened to the testimony the other day in committee, and I listened to the gentleman from Lincoln today, I commend the gentleman from Lincoln, the lady from Jefferson, and everyone that worked on this task force. Having had birth moms and adoptive moms, and sometimes been that in between over the years, but having served on Health and Family Services or Human Services Committee for 12 years, all of us that have been in that committee have listened to countless stories, countless heartbreaking stories. We've also, in the General Assembly, had members and constituents come to us with their challenges, where we want every child should be playing with their neighbor, making happy family memories. We know that that's just not been the reality. And I said the other day this was a landmark, and the gentleman